And one of the more important cases in recent times is the case in Re Alan Tantleff, the decision of Justice Abdullah in June 2022. I just want to touch on that case, and then we can discuss and ask some questions about that case. Now, this is the case arising from the Eagle Hospitality Group. Now, the entities in the group, REITs and 2 Singapore subsidiaries, applied for Chapter 11 relief in the US. The COMI of the entities was in the US. The Chapter 11 plan was confirmed, and the applicants applied to the Singapore High Court for recognition under the model law. Now, on the 2 Singapore subsidiaries, the US Chapter 15 was the COMI. The issue then becomes as whether the US Chapter 11 plan and confirmation order should be recognized, and if so, on what basis. Importantly, Justice Abdullah noted the commercial objectives of the application. It is to resolve the liabilities of the group in accordance with the Chapter 11 plan, prevent creditor action in Singapore, and then later for the Singapore entities to be wound up and dissolved eventually. On the basis of recognition, the judge looked at 2 possible bases. One is Article 2H of the model law, which is definition of foreign proceeding. The question is, does the Chapter 11 proceeding fall within the definition? Now, one prerequisite of the definition is that the foreign court must exercise control or supervision of the property and affairs of the debtor in that proceeding, in the foreign proceeding. The issue is whether the US court continues to exercise control or supervision of the debtor's property and affairs after the Chapter 11 plan has been confirmed. The judge then looked at the other basis of recognition, which is Article 21(1)(g), and in essence, Article 21(1)(g) of the model law says that when a foreign proceeding is recognized as a foreign main or non-main proceeding, the court may then grant any appropriate relief, including the list of relief set out there, which includes the stay of legal action, entrustment of assets to the foreign representative, and so on. Justice Abdullah looked at the case law in the US interpreting Article 21(1)(g), which is adopted in the US in the form of Section 1521 of the US Bankruptcy Code. And US case law makes it quite clear that Article 21(1)(g) extends to recognition of foreign insolvency related judgments and orders. And there are many examples where the US courts have recognized UK schemes of arrangements, which have been sanctioned by the English court. In contrast, there is a UK approach, and we have the UK Supreme Court decision in the case of Rubin and Eurofinance in 2012, in particular judgment of Lord Collins. Now, that case dealt with 2 foreign judgments. There was a US judgment for fraudulent conveyance, and there's an Australian judgment for unfair preference. The question is whether these foreign judgments can be recognized or enforced in the UK. The Supreme Court in Rubin said that there are no special rules of recognition of foreign insolvency-related judgments. You apply the same rules for all foreign judgments, which is, in other words, is the defendant present in the foreign proceeding, did it submit to the jurisdiction of the foreign court? Now, in addition, and importantly, the Supreme Court in UK then said that the model law and cross-border insolvency, which is incorporated in the UK by way of the cross-border insolvency regulations of 2006, is a procedural tool and is not intended to extend to recognition of foreign judgments. So Justice Abdullah and Re Alan Tantleff looked at the UK approach and the US approach, and His Honor decided that the US approach is preferable. In particular, Justice Abdullah looked at the draft Article 21(1)(g) of the model law in Singapore before it was eventually enacted. Now, the draft Article 21(1)(g) provided that the reliefs available included any additional relief that may be available to a Singapore insolvency office holder under the law of Singapore. Now, the phrase there at the end is under the law of Singapore. And in the final version of the model law that Singapore enacted, that phrase, under the law of Singapore, has been deleted. And in the judge's view, that was intentional to align the Singapore position with that in the US rather than in the UK. And that was also mentioned in the response from the Singapore Ministry of Law in the public consultation process. So that, in a nutshell, is the case in Re Alan Tantleff. And if I may ask some questions to Justice Abdullah.